Minister.
माननीय उपसभापति जी, इस कॉलिंग अटेंशन मोशन पर जैसा मैं हमेशा मानता हूं कि अगर सार्थक बहस करने का मूड बनता है तो राज्यसभा बहुत ऊंचाई पे पहुंच जाती है। और पिछले 1.5 घंटे में जो बहस हुई, जिसकी शुरुआत विवेक तनखा जी ने की, सतीश चंद्र मिश्रा जी, राम गोपाल यादव जी, डीपी त्रिपाठी जी, मेरे बहुत ही अंतरंग मित्र माननीय डी राजा, केशव राव जी, भूपेंद्र यादव जी, शिवा, इन सबों ने अपनी बात कही, बाकी लोगों ने भी कही। मैं सबका नाम नहीं ले रहा हूं, लंबी लिस्ट है। माननीय सदस्य राजीव शुक्ला जी ने एक आपत्ति उठाई कि जब कानून मंत्री कोई वकील बनते हैं तो जज का नाम देख करके परेशान हो जाते हैं। वैसे न्याय की पारदर्शिता के प्रति उनकी चिंता को देख के थोड़ा हमें कौतूहल अवश्य हुआ है, लेकिन वो विषय कभी बाद में चर्चा करेंगे। लेकिन हम उनको ये बहुत विनम्रता से बताना चाहते हैं कि नरेंद्र मोदी जी की सरकार में देश के कानून मंत्री के रूप में कॉलेजियम सिस्टम को बदलने का संवैधानिक प्रस्ताव इसी वकील कानून मंत्री ने लाया था। ये उनको ध्यान रखना चाहिए, ये बहुत मैं विनम्रता से बताना चाहता हूँ। और शायद इस खर्री बात को उत्तर समझने के लिए वो सदन में उपस्थित नहीं है। अगर होते तो उनका भी भला होता, कुछ मेरा भी भला होता, लेकिन ये कहानी कहीं और सही है।
He is coming.
आपकी बात कह देंगे।
He is coming when he saw you are speaking.
अब वो रिकॉर्ड में आ गया, बाद में पढ़ लीजिएगा। Now, sir, let me make certain general observations. In fact, I will go issue-wise, because issue-wise a lot of concerns expressed would be allayed. Let me first make a very general point. This government's commitment to the independence of judiciary is complete and total. And I say so because this government is led by the Prime Minister, Shri Rajnath Singh, Shri Arun Jaitley, Shri Sushma Swaraj, Shri Venkaiah Naidu, Anant Kumar, Kalraj Mishra, many others including me, who have fought against the emergency, suffered, where 3 freedoms were involved. 1, individual. 2, media. 3, independence of judiciary. Therefore, this government today, it is very important to be conveyed to this House, is led by leaders starting from the Prime Minister who have fought for the cause of independence of judiciary. It is good that independence of judiciary today has become an integral part of India's polity. That's the first thing I would like to say. The second thing, sir, regardless of all the limitations and gap areas which Honorable Ram Gopal ji also alluded to, our judiciary's record is indeed exemplary also, be it in terms of probity, be in terms of concern for the poor and underprivileged. Let us not forget, ultimately the Supreme Court laid benchmark in many cases of gross impropriety by governments of any party, which led to a new commitment about probity. The same Supreme Court talked about the rights of the poor and underprivileged in various PILs. Therefore, there are gap areas, I know that. But the larger commitment of the Supreme Court on these issues needs to be appreciated. Now, sir, why we are discussing it today? And I'm happy Honorable Sukhendu Shekhar Roy and Mr. K.T.S. Tulsi very rightly pointed out. Let me tell Honorable Chairperson, sir, on 13th of April 2015, the National Judicial Appointment Commission Act was brought into force. Thereafter, it was challenged. Now, once the law had come, all the members would realize immediately, and obviously you being an eminent lawyer yourself, Navneet Krishnan ji, that the bill, this constitutional amendment has completely removed the collegium system. For a new system, an appointment commission was to come into existence, consisting of the Chief Justice, 2 senior judges Supreme Court, the Law Minister, 2 eminent persons, one of SC, ST, woman or tribal minority category. And those 2 eminent persons were to be selected by a collegium of the Prime Minister, the Leader of Opposition in the Lok Sabha biggest party, and the Honorable Chief Justice. But before that could commence, it was challenged and all the appointment got stuck. Therefore, in installing the appointment, I am grateful to the two honorable members. The government did not play any role at all. Thereafter, the judgment comes on 16/12/2015. Now, Deputy Chairman, a lot of my distinguished friends had concerns of the rights of Parliament. I will immediately come to that, and Naresh Agrawalji just talked about Article 368 as well. But even before I could move this bill, on 26th of May 2014, I took the oath as the minister in Shri Narendra Modi's government. And I was grateful he also entrusted me in the law ministry then. And I would like to tell respected Ram Gopal Yadav ji, Shri Satish Chandra Mishra, who also espoused this cause, my good friend Mr. D. Raja, about the rights of the marginalized communities. And Deputy Chairperson, sir, the first letter I wrote to all the Chief Justices of High Courts of India was on the 21st of July 2014. And here I am quoting from that letter. The need for giving representation to scheduled caste, scheduled tribe, other backward classes, minorities and women may also please be kept in view while making recommendations for fresh appointment to the High Court. Therefore, one of the first initiative I took after I became minister was to write like this. Not only me, Deputy Chairperson, sir, even thereafter, my distinguished successor, Mr. Sadananda Gowda, on 30th of December 2015, when the whole process commenced, again mentioned the same thing. The need for giving representation to scheduled caste, scheduled tribe, other should be taken care of. Therefore, I hope Honorable Satish Chandra Mishra ji, Mr. Navneet Krishnan, Sukhendu Babu, Mr. Tulsi, and all other knows, collegium system is not in the Constitution. Yes. It is also not created by the Act of Parliament. Collegium system is a judge-made institution. This has to be clearly understood. But where they said now we will make recommendations. Sir, I would like to make two observations here. And this observation I am not making as a law minister of India, but I am making this observation as a student of India's constitution and law. The crux of the judgment of the 5 judges of the Supreme Court is that we are annulling the National Judicial Commission Act because law minister is a part of the selection process. Law minister is there, therefore a litigant who is appearing before a judge who has been appointed by the law minister also in that process will have doubts about the impartiality of that judge. Therefore, it is violative of basic structure. The second, the two eminent persons are also the same part, violation of the basic structure. Naresh ji asked about Article 368. Yes, we have got the right to amend the Constitution. But the honorable judges say, we have got the right to define what is a basic structure. And if any amendment violates the basic structure, we can annul that. And here they said, even though the Parliament has passed this law by 99.99% support, only one member of this House walked out, yet we say it is violative of basic structure. That's how it stands. But what is my question I'm asking, sir? And today I would like to share this before this honorable House. If a mere presence of law minister leads to doubt about the independence of judiciary, it is a loaded statement being made. It is the profoundest. We have opened the judgment. I'll come to that separately. But since House has asked a lot of questions, Deputy Chairperson, sir, the Prime Minister of India, even in the present regime, all the file will pass through me. It will go to the Prime Minister. It will go to the President. And today the Prime Minister of India is the central figure in appointment of the President, of the Vice President, of the 3 chiefs of the armed forces, of the CAG, of the CVC, of the Election Commission and Chief Election Commissioner, along with consultation process. The Prime Minister of India is given by the people of India the mandate to defend India. to maintain the unity and integrity of India. The Prime Minister can be entrusted with so much of constitutional trust by the people and the polity of India. How is it the Prime Minister cannot be trusted in the appointment of a judge or to the law minister? There's a larger question to be considered. Sometime the polity will have to consider that question. The second thing, Honorable Deputy Chairperson, sir, the second thing which I would like to highlight today is this judgment came in the year 1993. The Constitution came into being in 1950. From 1950 till 1993, that's been 43 long years. The law minister was integral to the process. Many times the chief minister was integral to the process before even the chief minister came. That is past. But let me ask a question today. There have been problems during emergency or in the regime of some particular law minister. But sir, some of the finest judges of India who are beacons of India's judiciary were appointed by the same process where law minister used to play a part. Who are they? Patanjali Shastri, Gania, Gajendra Gadkar, Hidayatullah, Krishna Iyer, Venkat Chalaiya, Chandrachud, Bhagwati, who led to PIL, or J.S. Verma, all are appointees of the same process. And I would like to ask Satish Mishra ji, Mr. Tulsi and Sukhendu Babu, has the collegium system produced any judge of that intellectual caliber or independence? That's a larger question to be considered at some time in future. But what I'm saying today, sir, is that we have accepted this judgment. Regardless of our reservations, a lot of questions were asked, are you willing to come again for this law? The polity will have to take a call. I cannot make any commitment today. After all, GST we had to, माननीय राम गोपाल जी कितनी मेहनत करनी पड़ी 1.5 साल की जीएसटी पर एक सर्वानुमति के लक्ष्य पर पहुंचने के लिए, तो वो भी एक पीड़ा होती है। अगर कहीं ना कहीं इस देश की राजनीतिक संदर्भ को उस सर्वानुमति की सीढ़ी पर चढ़ने का मन करेगा तो रास्ता निकलेगा। अभी उसके बारे में कोई टिप्पणी करना मेरे लिए उचित नहीं होगा। But sir, we have accepted the judgment in all humility. And here I would like to inform Mr. Vivek Tankha, honorable member. He's a distinguished colleague of mine in the profession. We have appeared together and opposed each other in many cases. But you are junior to me in the parliament. At least allow me to make that indulgence, okay? I came in the parliament in the year 2000. Now it is 17 years. You have come this year, okay? Therefore, I'm only 17 years senior to you in the parliament. Having said that, let me say my basic point. We don't intend to have veto on judiciary. No, sir. I want to make it very clear with the full authority of the government and the Prime Minister. We don't wish to have any veto over the judiciary. No. Jara sahab, sir, inko jara.
अरे सुने दो. No, listen to, no. No, listen to the. No, that is in between them. That is in between them. He made only a statement of fact. There is nothing wrong.
सर अगर विवेक तनखा जी को इस पर आपत्ति होगी तो मैं विड्रॉ कर लूंगा, लेकिन इस सदन में सीनियर वकील को जूनियर रखने की इजाजत नहीं है, ये मैं कहना चाहूंगा. Now sir, what I was trying to say, that we have accepted the judgment in all humility. But I want to make it very clear to this house, sir, and it's very important, that the right to reframe the MOP has been given by the Supreme Court to us. It is not a job which we are taking suo moto. The Supreme Court had said the present collegium system needs improvement. The Supreme Court had said, please take suggestion from the public of India. And yes, Honorable Sukhendu Babu, you are right. If you have any specific suggestion to give, I undertake, I will convey to the judiciary that these are suggestions of some of my... That Parliament should decide. All right, I'll come to that. Debate part, I'll come to that. Therefore, that point is fairly well taken, sir. About 3,000 suggestions came, 500. We collated it, 1,450 have gone there, sir. Now, sir, why the Supreme Court asked us to reframe it? My distinguished colleague, Honorable Bhupen Yadav, has very rightly stated they framed 4 issues. And, sir, I have got the judgment with me. Let me read from the judgment itself, sir. instead of quoting it otherwise, they say, the concluding part, the memorandum of procedure may provide for any other matter considered appropriate for ensuring transparency and accountability, including interaction with the recommended by the Collegium of Supreme Court without sacrificing the confidentiality. And earlier they say, sir, 4 issues which they say very clearly, and what the 4 issue is? Existing memorandum procedure with the object of considering criteria of benchmark for appointment of judges and higher judiciary, including widening the zone of consideration, to introduce transparency in the matter of appointment, to make the present procedure broad-based by introducing supporting measure, etc., the argument they are noting, and then they say do like this. Therefore, the Supreme Court itself acknowledged that the collegium system has a lot of limitations which needs improvement. The second thing they acknowledge, that element of transparency may be missing or maybe not that prominent. Therefore, reinforce the transparency mechanism. Thirdly, let the appointment process be more predictable. Therefore, come with the eligibility condition in a more proper manner. So these are the issues which they themselves stated. Sir, these are not my views. But out of 5 judges, 1 was dissenting, Honorable Justice Chamveshwar. He is dissenting, I'm not reading that. But 2 honorable judges of Supreme Court, who form the majority of the 5 judges, have written in their judgment, which is again a public document, and sir, I would like to read that, 4 or 5 lines of each. This is by Honorable Justice Madan B. Lokur. But it must not be forgotten, I'm quoting, not my word, but it must not be forgotten that the executive had an equally important participative role in the integrated process of appointment of judges. That the executive adopted a defeatist or I don't care attitude is most unfortunate. The collegium cannot be blamed for all the ills in the appointment of judges. The political executive has to share blame equally, if not more, since it is mortgaged its constitutional responsibility of maintaining a check on what may be described as the erroneous decision of the collegium. A Supreme Court judge, a part of the majority, is writing in his judgment. Not my word, I want to make it very clear. The second, Justice Kurian Joseph, again distinguished judge. And this is a little long, he comes from your state and a very distinguished judge of India. I have great personal regard for all the judges, for him in particular, what he writes. All told, all was and is not well. To that extent, I agree with Chalmeshwar J. The present collegium system lacks transparency, accountability, and objectivity. The trust deficit has affected the credibility of the collegium system, as sometimes observed by the civil society. Quite often, very serious allegations and many times a not unfounded too have been raised that its approach has been highly subjective. Deserving persons have been ignored wholly for subjective reasons. Social and other national realities were overlooked. Certain appointments were purposefully delayed so as either to benefit wasted choices or to deny such benefit to the less patronized. Selection of patronized or favored persons were made in blatant violation of the guideline, resulting in unmerited, if not bad, appointments. The dictatorial attitude of the collegium, seriously affecting the self-respect and dignity, if not the independence of judges, the court, particularly Supreme Court, often been styled as the court of collegium, the looking forward syndrome, affecting impartial assessment. These are not my words. They are words of the Supreme Court, of the majority judges. And what ultimately he writes, Honorable Deputy Chairperson, the active silence of executive in not preventing such unworthy appointments was actually one of the major problems. Honorable Mr. Vivek Tankha, let me remind you, the serious concern over the creeping limitations of the collegium has never been expressed by us in such eloquent words, where there is a recurrent recognition by 2 senior judges in a majority view that we have a role to play. We don't wish to exercise veto at all. But in the consultation process, in the very nature of the limitations which the law has given to us, we are trying to emphasize, and we shall continue to emphasize, that MOP needs improvement to make it more transparent, more objective, so that it inspires more confidence. That's what I have to say, because I want to make it very clear. Sir, on the issue of reservation, Satish Chandra Mishra ji, sir, I recall while I was moving this bill, I had, while replying to concern made by him and Mayawati ji, honorable member, that, sir, I'll just take 10 minutes, I'll finish. It's an important issue, can you allow it to me, sir? I had assured the House the Secretariat will come, it will maintain a proper catalogue of good lawyers of the Dalit community, of the OBC community, so that we can take a pool of those talented lawyers to be pushed around, to be pushed up for consideration. Because the law minister was to be there. Unfortunately, all have been struck down. But I can only say, reservation in a single post, constitutional post, is a larger debate. My good friend Mr. Raja, honorable member, talked about reservation for the deprived. I am completely with him, sir, as far as the rights of the deprived community is concerned. Yes, I had said this while moving the amendment bill in the House, and I repeat today, the judiciary of the day had to acknowledge that today judiciary has come into the focus of India's governance system, where those who are marginalized, those who are poor, those who are SC, those who are ST, think to have a stake. But that stake must come about minorities, those who are also competent. And I know in this country, good number of lawyers from these marginalized communities are good lawyers, are competent lawyers. Why they are not being considered? That's the question to be considered. And I can assure you, it is the focus of this government that in the whole process, whatever we can do as the Law Minister of India and the government, that those aspects, those people who are ignored must given a space would continue to be our endeavor. I want to assure this. Now, sir, certain larger questions have been raised. What about the role of the Chief Minister?
Yeah, that is also included.
Sir, I read in my letter itself, woman was mentioned.
Yeah, that is mentioned. Please.
Sir, there is no reservation in the higher judiciary. I was coming to that. Since you have raised this issue, I must reply to that. As of now, Constitution and all my distinguished members having knowledge of Constitution, Sukhendu Babu, Mr. Tulsi and others know it very well, Mishra ji, Vivek Tankha, that as of now in higher judiciary there is no reservation. Because the view is, it is a constitutional post. And if you think of a reservation in a constitutional post, you cannot stop only with the High Court judges, Supreme Court judges. There is Public Service Commission. There is an Election Commission. There is a CAG. There are many other posts. You'll have to think about that. Therefore, but there must be consistent endeavor to ensure that these marginalized communities are there. Yes, women should also be there. Why not? We will keep on thinking about that. In my letter itself, my great friend Shiva, I had mentioned that when I became a minister in July 2014 itself. Obviously, why not minority? Completely, they should be there. Now, sir, राम गोपाल जी ने एक विषय उठाया मुख्यमंत्रियों की भूमिका के बारे में. आपको मैं बहुत विनम्रता से बताना चाहूँगा कि MOP में अभी मुख्यमंत्री से सलाह का प्रावधान है. और हम इस बात की विशेष चिंता करते हैं कि जहाँ पर मुख्यमंत्री और राज्यपाल से भी भूमिका होकर आती है. लेकिन आपकी बात बहुत ही सही है, यह चर्चा आई है कि नियुक्ति की प्रक्रिया में मुख्यमंत्रियों को एक प्रभावी भूमिका मिलनी चाहिए, चर्चा होनी चाहिए. ये विषय आगे चल रहा है. Sir, I think the honorable members will have to acknowledge one thing. Sukhendu Babu, I am not running from debate in the parliament. But you are a very seasoned man who understands the constitution. When I am discussing the whole MOP with the judges, honorable judges, it is a process. Let that process be complete. I am dealing with something sensitive. You must understand that. And I want to tell all the members that we are alive to the concerns you have reflected here. So let that process be complete. Surely, we will do our best. Now, sir, a lot of questions have been asked about accountability. How can I run away from that? And the role of this House. As a member of this House, I want to convey to the honorable member that one of the first comments which I made as a minister, our judgment came, where I said, while upholding the majesty of independence of judiciary, the judgment has given a go-by to the majesty of the supremacy of parliament. I said it publicly. sometime or the other, this parliament will have to debate that larger issue. Our constitution has given very specific role of lawmaking to the parliament, governance accountability to the parliament, including today, if Mr. Vivek Tanka has moved this adjournment motion or call attention, I am replying to that. On behalf of judiciary, the good point I am acknowledging and also the minus point. That is the degree of accountability. And I don't think this constitutionally recognized supreme power of the parliament can be mitigated. But yes, one thing is there, that the law passed by the parliament or amendment are subject to scrutiny by the Supreme Court. That's what they have done, sir. So last quick 3 points, sir. A lot of issues, sir, have been raised by Mr. Tulsi about creation of impasse.
You need to reply briefly.
Very briefly. I want to assure there is no impasse.
I know, that's why 2 hours, look at that. How much time I allowed? In place of 1 hour, I allowed 2 hours. See that, please.
Sir, I want to assure Honorable Shri KTS Tulsi there is no impasse. As I said, there is no veto, there is no impasse also. But yes, if the Supreme Court has asked us to frame this particular MOP like the previous judgment in consultation with them, keeping the issue of accountability, objectivity, fairness in mind, it is my duty to convey in that consultation process, keep that in mind. And that we will continue to have that. Sir, Mr. Raja mentioned about certain acquittals. It is a serious matter. Mr. Raja, with your wide parliamentary experience, I hope you are aware that we have a principle in India, presumption of the innocence of the accused. Okay? And we have judicial process, conviction, acquittal or reversal. But yes, I quite take your point. The judiciary needs to have a sensitivity in case of massacre. Because if Dalits have been massacred, there has to be certain accountability of fixing the guilt on some persons. That is important. It is equally important that not only the trial, but also the investigation should be free and fair by those who are conducting the investigation. I think these issues will have to be taken into mind, sir. Sir, I think I have by and large addressed all the issues, if not especially. Yes, Mr. Keshav Rao mentioned about Telangana issue, sir. Sir, in his own inimitable style, he has always been espousing the cause of Telangana whenever I had occasion to hear him on legal issues, sir. I want to assure you we are in discussion. Your point is well taken, that Telangana needs to have representation, subordinate and higher. We are looking into it. Allow us to have that process. That's all I can assure you, sir. I think with this, sir, I have addressed all the...
Bench of the Supreme Court for the southern states.
It was that why, when the vacancies you say that there are more than 450 vacancies, the lower judiciary who are retiring at a particular age, why their names are not being cleared, number one. Number two, you have said that the Honorable Supreme Court has said that the executive cannot sit silently when unworthy appointments are being made. Can the executive sit silently when worthy appointments are not being made? We appreciate your stand and your action of sending letters to them to send these types of these names, this category names also, and your subsequent successor also. But have you returned the names that these names do not find place, and therefore I am returning them because executive cannot sit silently if worthy appointments are not being made?
Sir, 1 second. Mr. Deputy Chairman.
No, I can't allow all this.
The Honorable
I have
Minister.
to start the bill.
Sir,
I have to start. If I...
1 second.
If I allow...
1 second. The Honorable Minister, Sir, Honorable Minister has said that if there is a consensus in Parliament, he is willing to bring this bill again. Huh. No. So, who is preventing you? You can always bring the law. There was consensus in Parliament. 99% people voted for it. You re-bring it. We are ready for that. Secondly, independence of judiciary does not mean surrender to judiciary. And
that
secondly,
judiciary has explained very well.
Judiciary is ensuring, probity in public life.
No, Minister
what
has
about probity
explained it
within
very
the
well.
judiciary? Your comment should also be on that.
He has already explained it, but no need. I have to take up the bill. No. I have to take up the bill. This is,
इस पे जवाब आ जाए ना, इस पे जवाब आ जाए, अभी जवाब नहीं आया। अगर बिल ला लोग आप लाइए तो
okay.
Can I say something? With your permission. What I'm saying is, my intent was to ignite a debate where I have succeeded. Because nobody was debating
Okay.
this issue in
It was
this
a very,
country.
very good debate.
Number two,
Okay.
I'm saying today the judgment of the Supreme Court
No,
as
please.
it stands is final.
No, okay, fine.
So whatever we have to do is within the framework
he
of the
has
Supreme Court.
explained
And what I'm
very
saying
well
today is,
what
the
he's going to
Honorable
do.
Law Minister doesn't
Let
have
him-
that elbow
I'm
room
not
of a
blocking.
public interest
I'm not
rejection,
blocking.
which the newspapers have
Okay.
been reporting.
Do you have to say anything?
Unless
सर जो माननीय सतीश मिश्रा जी ने बात कही उसकी मैं पूरी चिंता करूंगा। आपको मैं ये भी कहना चाहता हूं कि जो निचले डीडी का नाम आते हैं उसमें भी काफी समस्या होती है, वरियों को छोड़ देते हैं, बट आई विल लुक इनटू इट, एक्सपेडाइट इट। सर टुडे 478 वैकेंसीज आर देयर, अबाउट 200 plus appointment is in process. The rest also I'm expediting. And kindly don't forget, when the judgment came in December, in January, we told the Chief Justice, kindly initiate the appointment again. So we have taken ourselves initiative. As far as you are, I know that regardless of the reservations of the House wholehearted, there is a judgment of the Supreme Court, which we have accepted in all humility and working accordingly in the parameters set by them. Sir, I'm deeply grateful,
Thank
sir,
you, thank you.
for giving me this opportunity.
I actually congratulate every member who participated. The discussion was of a high level, very good, very informative for me also. And the minister I congratulate. You explained it very well. Thank you, I congratulate. Now,